Good morning, everybody. Thank you for joining us for Oregon Business and Industries Paid Leave Oregon update. As I'm sure you're all aware, there have been lots of changes that are coming to Paid Leave Oregon and the Oregon Family Leave Act. We are very lucky to be joined by Stacie Damazo from Barran Liebman, who's going to give us an update on Paid Leave Oregon. Just a couple of housekeeping issues before we get started. This webinar will be recorded, so it will be available on the OBI website for anyone who wasn't able to make it today or wants to go back and listen to things. There will be time for questions. We were careful to leave plenty of time. We may not end up using all of that. If you do have a question, please use the Q&A function, which you should see at the bottom of your screen. We've scheduled this for an hour. We may or may not use all that time, but we wanted to make sure that we had plenty of time for questions. So I will now turn it over to Stacie.
Thank you, Paloma. Good morning, everyone. I'm going to share my screen. All right. All right. Well, thank you very much for interrupting, Paloma. And good morning. Thank you all for joining today to discuss complex leave administration and some of the changes that we will be seeing coming up this summer, some of which have already taken place. As Paloma mentioned, I am an attorney at Barran Liebman. We are a boutique labor employment law firm located here in Portland, Oregon. I represent employers in a variety of employment advice and litigation matters. And in my employment advice practice, I specialize in advising public and private employers on complex leave situations, including those involving Paid Leave Oregon, OFLA, FEMLA, ABA. So today we will be discussing Senate Bill 1515, which came out of the Oregon legislature's short session earlier this year. We will talk about changes that take effect in pretty short order, so on July 1st, how to prepare for those. We'll discuss recent proposed administrative changes that impact Paid Leave Oregon, OFLA, and Oregon sick leave as well. There are a number of changes to discuss, and we are trying to leave some time for questions at the end. So I won't necessarily be monitoring the Q&A as we go along. We'll reserve those for the end. Of course, if you have any questions, as Paloma mentioned, feel free to enter them in the Q&A box. And if we aren't able to get to your question for some reason, or something strikes you after we conclude today, my contact information will be available on that last slide, so feel free to reach out with any questions after we. All right, so because there are a lot of changes to discuss, I'm going to start by just making sure we're all on the same page. Now, I'm not going to spend a ton of time rehashing each and every update we've seen over the past few years. But I will start by providing big picture overview of both Paid Leave Oregon and OFLA today in their current form. As part of that discussion, we'll discuss what coordinating protected leave looks like today. We'll also highlight some of the recent amendments to OFLA and Oregon sick leave that apply right now and what coordination challenges exist under this current framework. Then we'll turn to Senate Bill 1515. Most of which takes effect, like I said, this summer. We'll walk through those changes, including some of the more recent proposed rule amendments, and how these changes may impact coordinating protected leave moving forward. All right, so I'm sure you all know, Paid Leave Oregon was enacted in 2019. Contributions began in January of 2023, and benefits began in September of last year. I saw in the March notice sent out by the Oregon Employment Department, Paid Leave Oregon reported that as of March 26, it had paid out $306.6 million in benefits. So a lot of applications we're seeing and a lot of benefits going out. So let's touch briefly on what are qualifying reasons under Paid Leave Oregon right now. Under this current framework, we have kind of 3 different buckets of leave. Family leave, so this is time to care for or bond with the child during the first year after their birth. Time to care for a family member with a serious health condition. Also medical leave, which is for the employee's own serious health condition, and then safe leave, of course, to seek medical, legal, or law enforcement assistance due to domestic violence, sexual assault, stalking, or harassment. Leave not qualifying under paid leave Oregon as a covered reason for leave includes OFLA bereavement leave, OFLA sick child leave, Oregon military families, the OFLA, and FEMLA's called active duty and hindered service member. Currently, duration of benefits an employee may be eligible for under paid leave Oregon is in part dependent on the qualifying reason, but also whether the employer is covered under OFLA, and if they are covered, whether the employee is OFLA eligible. Okay? So if the employer is not OFLA covered, what we're working with are that first bullet point plus that third bullet point. I apologize for this may be confusing if you're reading it on the screen, but general rule is that the employee may be eligible for up to 12 weeks benefits under paid leave Oregon per benefit year. Plus, and we're going to jump to that third bullet point, plus possibly 2 additional weeks of paid benefits for limitations related to pregnancy, childbirth, or related medical condition. Now, if the employer is OFLA covered and the employee is OFLA eligible, we're going to work with the second and third bullet points. So, as a general rule, employee may be eligible for up to 16 weeks per benefit year. So that breaks down into 12 weeks of paid benefits under paid leave Oregon, plus a possible 4 weeks of unpaid leave for an OFLA qualifying reason, again, if the employee is OFLA eligible. In addition, those 2 potential weeks for limitations related to pregnancy, childbirth, or related medical condition may also be added in there. So if not OFLA covered, 12 plus the possible 2, if OFLA covered, 16 plus the possible 2. Okay, so for those of you who've been tracking this issue involving the use of accrued paid benefits during a period of leave under paid leave Oregon, you will have noticed that the law with respect to this issue has gone back and forth. Initially, so pre-Senate Bill 913, employers could come up with the difference between the benefits an employee received from the state under paid leave Oregon and the regular rate of pay by either affirmatively providing a benefit to pay that difference or allowing employees to use their accrued paid benefits of sick leave, PTO, the other paid benefits to bring them up to that 100% in wages. That language is important. So the limitation here is that employees can only be, quote, true up to 100% in wages. What that means is the employer needed to know how much the employee was actually receiving from the state so that the employer would calculate what the difference would be, not go above that 100% cap. Now, during the 2023 legislative session, Senate Bill 913 passed, which removed that cap, removed that 100% in wages language. So under Senate Bill 913, so right now, employers may permit employees to use all or a portion of their accrued paid benefits during a period of leave under paid leave Oregon. That cap is no longer in use. All right, so moving to OFLA, similar to paid leave Oregon, we've got some familiar language here on the screen in terms of what a qualified reason for leave under OFLA may be. We have family leave, medical leave, and it's subsumed in there. We specifically have pregnancy disability leave called out, sick child leave. Now, this includes time to care for a child who's suffering from an illness, injury, or condition that is not a serious health condition, but that requires home care, This is the current language of OFLA. Qualifying reason under OFLA also includes bereavement leave and foreign military family leave, so all not elect. Now, under OFLA, duration of leave looks a little bit different, depending on qualifying. So we could have up to 36 weeks, depending on potential qualifying reasons. So 12 weeks of family leave within any 1 year leave year, 1 year period. That includes a total of 2 weeks of bereavement leave. Then we have a possible 12 weeks of pregnancy disability leave. And then we have a possible 12 weeks of sick child leave if the employee has already exhausted the 12 weeks of their family leave in the same leave year. Now we talked about highlight with Paid Leave Oregon, what the use of accrued paid benefits looks like under Paid Leave Oregon. Do want to touch on it with OFLA because we'll see this become relevant in a little while. But in general, under OFLA right now, an employee is entitled to use their accrued paid time off during a period of OFLA. I'll just call out now that entitlement is different than what we currently have in the Oregon's rules. The language for the Oregon is that the employer may permit the employee. Okay, so key difference in language here. So the employee gets to choose under OFLA whether or not they want to use their accrued paid time off during that OFLA leave. With that said, an employer may require an employee to use their accrued PTO paid benefits during a period of OFLA leave, provided they follow written notice requirements. Okay, so general, the employee gets to choose, but the employer may require. So current OFLA language. Okay, so what does that leave us with today? Big picture, employees have up to 4 banks of protected time off to work with. This is the current framework. FEMLA, OFLA, Paid Leave Oregon, and Oregon sick time. Of course, that assumes the employer is covered under all 4 of these laws. Also worth incorporating up here, though slightly different and not necessarily the topic of today's conversation, but don't forget the ADA, potential unpaid leave as a possible reasonable accommodation. But so really these 4 banks of protected time off. Now the general rule is that OFLA and FEMLA leave would run concurrently with Paid Leave Oregon benefits if a qualifying reason is a qualifying reason under all 3 of those laws. An important note here, however, is a 9th Circuit case called the Scriba, which says that any employee may defer the use of their FEMLA for later use. So what this means is that under a Scriba, an employer cannot require an employee to take their FEMLA leave. They can choose to defer their FEMLA leave if they choose. Foley has historically applied a Scriba to OFLA. Last summer, we saw Senate Bill 999 pass, which affirmed that Paid Leave Oregon and OFLA run concurrently where possible. So right now, there's an open question as to whether a Scriba still applies, but generally speaking, concurrency where possible. We'll get in here in just a moment how employee choice may complicate the administration of leave. But in general, our most difficult coordination topic when we start interacting with all 4 laws and get into this complex leave administration space is between OFLA and Paid Leave Oregon. Okay, so right now we have 7 different eligibility possibilities, and we won't go through all of the different possibilities, but just keep in mind, currently under the current framework, there are a lot of different orders in which an employee can choose to take leave. We have issues arising out of the quote eligibility gap and employees' choice. So some of those coordination challenges include eligibility timeframes. Paid Leave Oregon The threshold for eligibility for leave is relatively low compared to OFLA, compared to FEMLA. So an employee may become eligible at different times under all three, or will become eligible at different times under all three of these laws. Another coordination challenge is how we're defining the leave or the benefit year. Senate Bill 999, which passed last summer, it allows us to align OFLA's leave year with paid leave Oregon. In fact, starting July 1, 2024, OFLA will only allow for the same leave year as paid leave Oregon's benefit year. So that would be a rolling forward benefit year with a start date of the Sunday prior to the date the leave begins. If FEMLA allows for, if FEMLA hasn't changed for those of you who are FEMLA covered, rolling forward, rolling backward, calendar year, or a leave year that is required by state law. Another coordination challenge is the definition of family member. Now we have paid leave Oregon and OFLA aligning in how they're defining the definition of family member. But FEMLA does not incorporate that same definition. In fact, FEMLA does not cover many of the other relations included in the definition of family member under OFLA and Oregon. So it's something to certainly keep in mind if an employee is taking to care for a family member. And then of course, employee choice, right? Employees cannot be forced to take OFLA, FEMLA, or paid leave Oregon. So for example, they could opt to take OFLA first and apply for paid leave Oregon later. Now, I won't spend too much time talking about the complications here of employee choice under the current framework, because the changes to paid leave Oregon and OFLA and Senate Bill 1515, challenges relating to concurrency or employee choice are not as prevalent. And so let's talk about Senate Bill 1515. As I mentioned, this came out of the short session earlier this year. Many of the changes are effective July 1, 2024. We'll start with changes to paid leave Oregon, and then we'll discuss OFLA separately. So one of the primary changes or key changes to flag in Senate Bill 1515 specific to paid leave Oregon is the treatment of accrued paid benefits during a period. Under Senate Bill 1515, employees may decide whether to use any accrued PTO. This is no longer an employer may permit issue. That language, that entitlement language that we see in OFLA is now in paid leave Oregon. So employees get to choose whether to use that accrued benefit during a period of leave under paid leave Oregon. However, if they decide and choose at the same time, if they choose to use their accrued paid benefits, the total amount received by the employee may not exceed an amount equal to the employee's full wage replacement. So we're not quite going back to that 100% cap language, but we will have a cap in place here, and that's the amount of the employee's full wage replacement. This was an opportunity for the legislature to clarify what they mean by full wage replacement. For example, is it the regular pay at the time the employee went out on leave? Are we relying on the recalculation base year divided by 52? Hopefully we'll see some more clarification come as they revise the rules in advance of July 1. But just kind of an issue to flag or to know to continue to track as we move along. This also means that the employer must still rely on the employee to report how much they were actually receiving benefits from paid leave Oregon, so that we can make that calculation as employers. Now, so the general rule that the employee may decide, and if they do, we need to keep that cap in mind, that full wage replacement number. However, an employer may still permit the employee to use their PTO such that the total amount exceeds that full wage replacement amount. So if you can allow the employee to exceed an amount equal to their full wage replacement. If you choose to do this, of course, best practice would be to make sure this is incorporated into your written policy. Candidly, a pro of allowing this would be reduces the administrative task of collecting how much the employee is receiving, doing that calculation. So there's some administrative ease in allowing employees to go beyond that full wage replacement amount. Another change we saw in Senate Bill 1515, as I'm sure you all know, previously, if an employee was eligible to receive unemployment benefits, they were disqualified from receiving benefits under the Oregon during this. This has been expanded a bit, so now the Senate Bill 1515 adds that employees who are eligible to receive time loss benefits are also ineligible for daily Oregon benefits. So unemployment and time loss, so workers' comp. And Senate Bill 1515 clarifies that daily Oregon benefits are exempt from garnishment. There are some exceptions. So for child or spousal support or restitution for benefits. Okay, so I mentioned this earlier, but the bulk of the changes that we see in Senate Bill 1515 relates to OFLA. Let's dive in here. Primary change is to the qualifying reasons for leave under OFLA. So OFLA will no longer cover parental leave or serious health condition leave, and that's for both the employee and of a family member. Now, put an asterisk by serious health condition leave for just a moment, and we'll return to this in a couple slides. Another major update that goes hand in hand with these changes is that Daily Oregon and OFLA will no longer run concurrently. So those qualifying reasons of leave that overlap between Daily Oregon and OFLA have now been parsed out, and generally speaking, will only be covered under the Daily Oregon. Another change to OFLA came through the bereavement leave, OFLA bereavement leave. So Senate Bill 1515 places a cap on the amount of bereavement leave a covered employee needs per leave year. So now we have a cap at 2 weeks of bereavement leave for death of a family member and 4 weeks of bereavement leave per year total. Sick child leave under OFLA is also expanded under Senate Bill 1515. So starting July 1, an employee may take leave under OFLA to care for a child suffering from any illness, injury, or condition that requires home care, even if it may qualify as a serious health condition. An employee may still use OFLA's sick child leave to care for a child whose school or place of care has been closed in conjunction with a statewide public health emergency. But the real change that we're seeing here is exactly what's on the screen. That language is removed. Now remember, I asked you to place an asterisk here a couple of slides back. With the change to sick child leave here, there is a sort of carve out. So again, under Senate Bill 1515, generally serious health condition leave will now explicitly be a qualifying reason under Daily Oregon, except OFLA sick child leave may include conditions that qualify as a child's serious health condition. Senate Bill 1515 also temporarily amends OFLA to cover 2 additional weeks of leave for the fostering or adoption process. This provision will sunset on January 1, 2025. So between July 1 and December 31 of this year, an employee may take these 2 additional weeks of OFLA to effectuate the legal process for placement of a foster child or the adoption child. Now, the reason this sunsets under OFLA on January 1, 2025, because effective that same day, Senate Bill 1515 amends family leave under paid leave Oregon to include this same qualifying reason. So for these first 6 months, it's an unpaid 2 weeks under OFLA. That will sunset, and then it becomes a qualifying reason for paid benefits under paid leave Oregon. Small change to OFLA's notice provision. So in general, employers may still require written notice at least 30 days before starting leave. However, there are some exceptions. So an employee may start leave without prior notice if the leave is for an illness, injury, condition of a child that requires home care, to death of a family member, or pregnancy disability. And in terms of treatment of current OFLA leave for family members who are both employees, family members may not take concurrent OFLA leave. A couple exceptions to note is if one employee is taking sick child leave and the other is taking pregnancy disability leave, or if one or more of the employees is taking bereavement leave. Now, I do want to just flag, I think, this predictive scheduling relief in Senate Bill 1515 has been getting overlooked with some of the bigger changes that we're seeing to OFLA. So it is related to leave administration, so I just want to take a moment to call this out. With Senate Bill 1515, employers will be exempt from predictive scheduling penalties if an employee is provided less than 14 days notice of either they're needed for leave or their return from leave under, this could be paid leave Oregon, OFLA, or any other leave under ORS Chapter 659A. It would be less than 14 days notice, and the employer has made a change to the schedule of an employee who's temporarily assigned to cover shifts for that employee off. Okay. So we've walked through Senate Bill 1515 and some of those primary changes. After Senate Bill 1515, we started to see some of those administrative rule amendments. So in early March, fully proposed rules that would amend OFLA and Oregon sick time. Many of these proposed changes clarified definitions and kind of housekeeping proposals, eliminated unnecessary statutory citations. However, there are a few changes worth highlighting, so we'll walk through those. The first is that these proposed rule changes clarify that an employee may use their sick leave for any qualifying purpose under paid leave. This would include during a time during which the employee is receiving benefits under paid leave. The next few slides will cover relate to OFLA proposed rule changes. The first, we have a process now for an employer to require an employee who's using OFLA or sick time for an individual related by affinity to attest. So mirroring the attestation language we've seen in other places under paid leave Oregon. Another change is or proposed change relates to OFLA eligibility. So this one I'm flagging because in earlier versions of these proposed rules, we saw a change that would actually require employers to exclude the consideration of protected leave or looking at calculating an employee's average hours of work per week for OFLA eligibility. So I just want to put this back on the screen in case you saw that change. We're actually changing it back to what it used to be before those initial proposed amendments were rolled out. So for purposes of OFLA eligibility, to determine an employee's average hours of work per week, employers must count any hours of protected leave taking, including OFLA leave, as well as the employee's actual hours. OFLA rule changes or proposed rule changes, I should say. So we saw an elimination of the requirement that a domestic partner be the same gender as the employee. This is in alignment with other changes that we saw in the 2023 session. We also saw changes to the definition of serious health condition and pregnancy disability. So these are now proposed to be amended to include period of disability due to pregnancy termination or fertility or infertility. We also saw the addition of a proposed rule that clarifies if an employer transitions, or when an employer transitions their OFLA leave year to the new rolling forward leave year, employees must be provided a new full thing of leave. This particularly, if you have not already transitioned your OFLA leave year, note that that will be the only OFLA leave year available starting July 1st. So this in particular will be important to keep in mind that employees at that point must be provided a new full leave. All right. We saw a change to location and slight change to the language, but under these OFLA proposed rule changes, an employer may require the employee to provide verification from their healthcare provider that they're able to return to work. If an employer is going to require this verification, you must apply the practice uniformly and pay for medical verification. Now, the big news, kind of save the best for last, I suppose, or the biggest for last, but a real key proposed rule change to keep in mind is how use of accrued benefits will operate under OFLA should this rule become final. So we talked about earlier the entitlement language under OFLA. So an employee is entitled to use those accrued leave benefits. They get to choose. But an employer may require use if they follow those right notice provisions. That language that allows an employer to require use of PTO has actually been removed. So if that rule takes effect in its current form, employers are no longer going to be able to require an employee to use or exhaust their PTO during the period of OFLA leave. Instead, what we're left with is the language that the employee gets to choose. They have that entitlement to use their accrued benefits. So an important one to flag, an important one to keep an eye on as the rules potentially become final. Okay, so those were the proposed rules. We do have a temporary rule issued by Foley, got the actual language up there on the screen. Under this temporary rule, this is particularly relevant for those of you who are OFLA covered. If you have, for example, an employee already out on OFLA leave right now, and that leave will extend past July 1st, you can, and I should say the qualifying reason is no longer an OFLA reason on or after July 1st because of the changes we've seen in Senate Bill 1515. You may rescind your prior designation or approval of that leave after July 1st as OFLA leave. But, excuse me, this notice requirements, this was if you did this prior to June 1, there were certain notice provisions required. So it had to be notification in writing, and you had to provide written information to the employee about how they can apply for benefits under Predictive. Now, the next part is what will continue to be important. If you receive a new request for leave for an employee who's out on OFLA leave, or an employee who wants to take leave or is requesting to take leave for a reason that would have been protected by OFLA. So new request for leave, you must, as soon as practicable, but no later than 14 calendar days from the request, inform the employee in writing that they can apply for benefits under Predictive and provide them the relevant contact information. So for those of you who are working with state plan, you can provide the model notice provided by OED, Oregon Employment Department, on their website, or provide the contact information for your employment administrator. This rule is in effect until July 1, so only through this transition period. And I'll just flag that the language of the rule is broad enough. So this doesn't just apply to an employee who specifically says, I would like to take my OFLA, or I want to take serious health condition under OFLA starting June 30th, right? So this rule would also apply to the more vague request for medical leave that's void of any reference to OFLA. Okay, so we walked through the eligibility possibilities right now in terms of complex leave administration. Big picture, what we're left with starting July 1st in light of Senate Bill 1515. With respect to paid leave Oregon, we don't see too many changes here. So qualifying reasons for leave remain relatively unchanged. We still have family leave, with the caveat that child placement leave will be a qualifying reason beginning January 1, 2025. So medical leave and sick leave. And the change here is with respect to the duration of leave. So beginning July 1, employees may be eligible for up to 14 weeks of benefits. Still have those 12 weeks, kind of that general rule of paid benefits, whether the reason is family, medical, or sick leave, plus those potential 2 additional weeks for limitations related to pregnancy. Now, OFLA, qualifying reasons have changed pretty substantially. So we have sick child, bereavement, pregnancy disability, OFLA, and then those temporary 2 weeks of child placement. In terms of the duration of leave, OFLA still allows for 12 weeks of sick child bereavement leave, and an additional 12 weeks of pregnancy disability leave. And again, just temporarily, these 2 additional weeks of leave for child placement. Quick note that I want to highlight, I'm not sure if I've mentioned this previously, but with respect to pregnancy disability leave, we've seen in the proposed rules that an employer may now seek medical verification for an employee's pregnancy disability. Okay, so previously we saw 7 different eligibility possibilities. Moving forward, see 5, and this again assumes the employee or the employer is covered under FEMLA, OFLA, and so what can we do to get ready for July 1st? If you haven't already, recommend that you take a look at your leave policies. Provisions, based on the changes that we've been discussing today, to keep an eye out for are ensuring the benefit leave year definitions are aligned. Integrate, as we started to see the concurrency and the employee choice developments, a lot of folks opted to integrate all of their leave policies and the combined FEMLA, OFLA, leave Oregon policy. Now that we're seeing these changes to the qualifying reasons and no concurrency between leave Oregon and OFLA, recommend that you take a look at those integrated leave policies and consider separating those out. Make it clear what is a qualifying reason under each of these laws. To the extent that you allow an employee to true up, and depending on what form you allow that to take place, whether you are affirmatively providing the benefit or if you're allowing an employee to use their accrued paid benefits to make up that difference, consider whether the reasons why you offered that in the first place still stand in light of these changes. And then evaluate whether, as a practice, you intend to permit employees to use their accrued paid benefits in an amount that exceeds their full wage replacement during a period of leave under ordinance. If so, like I mentioned before, I would recommend incorporating that into your written policy. In addition, keep in mind that that temporary rule, be sure to inform employees about upcoming changes as required by that rule. Update those leave tracking systems. The primary change here will be ensuring you understand what is a qualifying reason for leave under Predictive Oregon versus OFLA, and of course accounting for different definitions of family member under Predictive Oregon, OFLA, EMLA. And of course, watch for revised rules and posters. We have seen the proposed administrative rules, so we should be seeing the final versions and tracking some of the issues that we've talked about today, and seeing if any of those maybe in the final form, and if so, making sure that you're prepared to modify policy language as needed. Okay, but hopefully that wasn't me talking too quickly. I wanted to make sure we got through the material and had time for questions. So Paloma, I'll invite you back and
Thanks, Stacie. So we got one question about if there's any trick at getting through to the Paid Leave Oregon team, through Francis or otherwise. I haven't found one yet. It's just a lot of time.
yeah, it's a waiting game. Continuing, I think I saw that at the outset, continuing to do what you're doing. Sending them, it sounded like it was through Francis only. Was that the question?
She said that, or they said that they had called too, but hadn't.
Okay. Potentially, so I've been getting a little bit better luck with email. It doesn't mean that it's quick, but it's continuing to do what you're doing.
We got several questions about whether or not the slide deck would be available.
So, we can certainly talk about it. Also, with it being the recording, I think that's another way to go back and review material. But yeah, I don't see an issue with that.
Then back on Paid Leave Oregon, are the 2 special weeks paid or unpaid?
I'm assuming if that's relating to condition, the additional 2 weeks of conditions relating to pregnancy or childbirth, yes, those are 2 additional paid weeks if the employee has one of those qualifying ones.
This one's sort of complicated. Regarding the post Senate bill leave, if an eligible employee wishes to use their paid vacation time while out on OFLA, can the employer restrict it to the typical 8 hours paid vacation a day, or can the employee demand a withdrawal of their entire account at once, which would not be allowed by the vacation policy, but seems to be allowed with the Senate bill?
Okay. So this is just OFLA leave, it sounds like, after Senate Bill 1515. The change to OFLA that I was referencing relates to these proposed rules. So right now, what would happen is the employee general rule is that can choose to use their PTO. And so if the question is, can they choose to exhaust all of their PTO, they can't. Now the employer can require that, and if it's depending on, you reference a specific policy, so it might be helpful to see how your policy itself is framing this issue. But in general, right now, the employee may choose. They have that entitlement. And Paloma, stop me if I'm already misunderstanding the question.
Well, I think it's also a question about whether or not can they use their out on OFLA.
So let's see if I can.
Could they use more of their? Could they cash out? I think is maybe one of the questions. All of the in excess of the amount of days or hours that they'll actually be gone. So right now, under the employer's policy, they're limited to using no more than 8 hours of PTO for each day they're out. I think the question is whether or not could an employee use more than that equivalent.
Yeah, so without seeing, and again, it's probably going to depend on how it's framed in the policy. Barring how that's framed, it is an entitlement. So again, I want to take a look at the specific policy before giving a specific answer either way. But that OFLA, we want to be careful about that entitlement in OFLA as it stands right now.
What documentation is needed for sick child leave?
Sick child leave under Senate Bill 1515, we can't require verification from an employee for sick child leave. So we'll see if there's any changes to the rules between now and July 1st, if we see those rules become final, but right now, I don't think there's anything in the rules that would allow an employer to require verification.
What if the employee was out for sick child leave for a full week?
Beyond those 3 days.
Yeah.
Yeah, I go back and check the proposed rules, but I don't think that we have anything in there that would allow an employee or employer to require the verification. Whoever asked that question, like I said, feel free to, that's one that I can certainly follow up with. So please feel free to send me an email and we can kind of follow up on this with you directly.
Then got a question. Thanks for taking. Who pays for medical benefits when the employee is out on leave? Does Oregon compensate the employer?
For medical benefits?
Yep.
Okay, so I'm assuming, I guess, the employee, I mean, the employer wouldn't be paying for medical treatments unless they're requiring, for example, the employee to go get a medical verification, something like that, relating to their own serious health condition. So I'm not sure I understand that.
So I think it's essentially the continuation of health insurance, I'm guessing.
Yeah, those rules have not been changed under OFLA. And in fact, those rules now apply via the Oregon. So the employee, you have language now in both rules, the Oregon rules and OFLA rules that require the employee to continue that health insurance. So we're back to kind of that default language for both. Whereas initially we were missing that component in the Oregon, but now the rules are pretty similar to OFLA in terms of continuation.
Lots of questions about the 3 days, which I think you already saw, so we'll follow up. We're both going to follow up on that one. Let's see. When an employee uses paid leave Oregon and are then eligible for an additional 4 weeks of OFLA leave, is that the same after July 1st?
No. And so that is a change in Senate Bill 1515, and with now the change that no longer is Oregon OFLA currently, we don't have those overlapping qualifying reasons with some of the asterisks that we've talked about this morning, but no, after July 1, the leave Oregon duration will be those 12 weeks of potential paid benefits for family, medical, or sick leave, plus those possible too. So up to the 2 weeks for conditions related to pregnancy. So up to 14 weeks, and those 4 potential unpaid weeks have been removed.
There's some other questions about paid leave Oregon and getting sufficient information to calculate the PTO topping off essentially. I'll just say that OBI is in frequent conversations with the department about how important it is that they start getting this information out and getting it in rules and easier for all of us to access. I don't have a resolution to report yet, but we are trying to get somewhere. So just something to note on that. So understand all these questions. We don't have good answers on that yet. Then I had a question here. Were there any changes in employer size that affect when a firm is covered under OFLA as less than 25 employees? I assume we only have Oregon paid leave to consider.
Right, no changes to the way employer size is considered under the rules. It's more than, and I would refer back to the language of the rule, but generally speaking, if you have fewer than 25 employees, you're not covered under OFLA. We're looking at some of the nuances just to confirm, but right, no changes to employer size for that purpose.
I believe there is a rule on this, but when employees return to work after being out on leave, can the employer collect the missing payments that were paid on the employee's health insurance that the employee would normally have paid?
Yes, yeah. So no loss of a right there. We see that in both the OFLA rules and the PB board rules.
Can you touch on the employees who are employed by a Washington state employer, live in Oregon, but commute to Washington daily? What is their eligibility?
So that is a great question and very nuanced. We have specific rules that we need to make sure it depends on where, how much work is being performed in each state. So I would encourage you to reach out. We can talk more about that offline. But that is unfortunately not a clear answer. We do need to go through the analysis to see what kind of work is being performed by a particular employee.
And go back to the top. Sort of a confusing question. Are serious health condition absences of less than 1 day protected under paid leave Oregon, even if they're not paid? Maybe they need OFLA. Not sure.
So yeah, if the way we would be protected under paid leave Oregon is if they've applied for benefits and been approved. Now they could use their paid leave Oregon benefits for example, a medical appointment. They would just need to take a full day. If we're talking OFLA, then yes, that could be protected because they can take their OFLA leave in increments of 1 hour, a day, work week, and that those increments don't cross over to paid leave Oregon. Paid leave Oregon is only 1 full day, 1 full work week. So I hope I've touched on that. If it's either OFLA or paid leave Oregon, but or feel free to clarify in the chat. We can be not following that.
So this is another question about the 8 hours. At present, paid leave Oregon still requires any leave to be taken in full day in 8-hour increments.
Correct.
Um, let's see. Question was, so an employee can essentially get 24 weeks paid off if they are covered under paid leave Oregon for their own serious health condition, then later qualify for OFLA for another 12 weeks.
So under Senate Bill 15, so moving forward, with Senate Bill 1515, medical leave will only be a qualifying reason for the employee's own condition under paid leave Oregon. And those benefits, or we've got that, those 12 weeks plus a possible 2. Now, depending on the reason for medical leave, if for example, it's a condition relating to pregnancy, they may be eligible for up to those 14 weeks. But generally speaking, that would be limited to 12 weeks. And generally speaking, they wouldn't be entitled to anything under OFLA, because OFLA is no longer going to cover medical leave. Unless there's something else going on, unrelated to the medical leave that they may qualify under OFLA for. Probably be looking at 12 weeks, maybe 14 under paid leave, or depending on the reason for the medical.
Thank you, Stacie, for being with us. Again, this the webinar has been recorded and will be available on the OBI website in a bit. I think we're still figuring out the slides, but if they are available, they will also be available on our website.
Thank you all.
Thank you.